Hello everyone, we are Group 10 and in this video we will explain about Articles of Associations AOA. Hope you enjoy the video.
When it comes to issues with companies, one of the terminologies that is most often seen is corporate constitution, which was once known as Articles and Memorandum of Associations. Both of these names refer to the same document. However, what precisely does it mean to have a constitution, and is it required for a firm to have one? The company's constitution, formerly known as the Articles and Memorandum of Association, spells forth its aims, functions, and internal affairs and administration. The corporate constitution also works as a contract that binds the firm, its shareholders, and its directors, and may include covenants and processes. The constitution is therefore more binding than a shareholders' agreement, which may not bind the directors who are not parties to the agreement. However, the article of association can be deemed to be more focused on matters of internal affairs. Next, we will be discussing about the nature of the AOA, which are: it must involve internal regulation. Second, it must not violate any laws. Third, the AOA cannot override and overrule any provisions that are in the MOA. And lastly, the document must be public and open for inspection.
There are 16 contents of Articles of Association AOA. It is started with office, Table A, preliminary contracts, classes of shares, line of shares, calls on shares, transfer of shares, transmission of shares, alterations of share, reduction of share, general meetings, directors, account and audit, dividends, notices, and winding up. Table A is preceded by the model articles set out in the schedules to the company's regulation in 2008, which provide respective defaults set on articles for public limited companies and companies limited by guarantee incorporated on or after that date, and also it's not required registered is AOA.
Form of AOA. Form of AOA is a document that specifies the regulations for a company's operations and defines the company's purpose. The document lays out how tasks are to be accomplished within the organization, including the process for appointing directors and the handling of financial records. All those documents must be printed and divided in numbered paragraphs. Types of company that requires AOA. According to the new law, Company Act 2016, under Section 38(3), there have been three types of company requires for AOA, which is limited by guarantee, limited by share, and unlimited company. First, limited by guarantee. A company limited by guarantee is required to state its objects in its constitution. Second and third, limited by share and an unlimited company. The company limited by shares and an unlimited company may adopt a constitution that states its objects, but is optional for the company to adopt a constitution. If the company decides, then the objects must be stated.
AOA and case. Section 10 declares the subject of provision of this Act. The memorandum and articles should, when registered, bind the company and the member thereof the same extent as if the respectively had been signed by the company by each member, and the content covenants on it and his part is observe all the provision of memorandum and article. The purpose of the section is to provide memorandum and article legal binding effect. Only the estate boundaries of the influence and the person it's meant to safeguard are unknown. The law case can be characterized by the idea First is the binding company to its member. Every member of the company is given some individual right under the Act and article. If the company has already committed the breach and any term, condition, memorandum or article, any member can sue the company, director and other officers who are responsible for the breach. Example, the case Wood vs. Odessa Waterworks. The director proposed to pay dividend in kind by issue the debenture. The article provided for the payment dividend. The held court that payment means payment in cash, therefore the company could be compliant in pay in dividend in terms article binding on the member in their relation to the company. It should be demanded this document were signed by every member of the company individually. Every member should be bound to comply by the provision contained in memorandum and article. The example of the case is the bond land trustee still bros, and the article of the company contained a clause on the bankruptcy of member. His share should be sold to other person and the price fixed by director. B. Shareholder was adjusted the bankruptcy. His trustee in bankruptcy claimed that he was not bound to this provision and should be liberty to sell share to the true value. Held, the trustee was bound by the article. Its share was purchased B in term the article. Between member, every member is bound to all the members. However, there is no privity contract between the member. But member may enforce his right against other member through the company and not directly. The example case is Rafley versus Hand. The article of the company provided wherever any member wished to transfer his share, he was under obligation to inform the director of his intention, and the director was under an obligation to take his share equally between them at fair value. The director refused to take share of the particular member. The Crown at the article did not impose an enforceable liability upon them. Is no binding in relation to outsider. The firm as well member is not obligated to the outsider to carry out the terms of the memorandum and article. Consider the following scenario: Ellie versus Positive Insurance Co. In this case, the article provided the solicitor the company will be removed the officer accept the misconduct. Ellie act as a solicitor to the company and also become the member of the company. The company does discontinue his service and sue the company damage breach contract. It was held and he had no causes action because the article did not constitute any contract between the company and himself. His action was dismissed.
Next is the differences between Memorandum of Associations MOA and Articles of Associations AOA. First, the meaning. MOA is a document that contains all the conditions which are required for the registrations of the company. As for AOA, it is the company that contains the rules and regulations for the administrations of the company. The second one, differences status. MOA is a subsidiary to the Companies Act, whereas AOA is a subsidiary to the both MOA as well as the Act. Next, major content. MOA must contain the 6 clauses. On the other hand, AOA are draft as per the discretions of the company. The fourth differences are compulsory filing at the time of registrations. MOA is obligatory to be registered with the Registrar of Company (ROC) at the time of registrations of the company. As opposed to AOA, it is not required to be filed with the registrar, although the company may file it voluntarily. The Act performs outside the scope of memorandum and article articles also differ. When it comes to scope, the acts performed beyond the scope of MOA are absolutely null and void. In contrast, acts done beyond the scope of AOA can be ratified by unanimous voting of all shareholders. Lastly, obligatory. All the companies need to oblige with the MOA, while the AOA is mandatory for the private limited companies only. As for the public limited by share, they can adopt Table A in place of AOA. To conclude, Articles of Associations is an important document in the business of the company. It is a document that outlines the duties and responsibilities of each director and the firm employee. It controls how the business is run inside. It is an important document that, along with the memorandum, serve as the company's fundamental constitutions and rule. It relates to the relationship between the company's member while defining the functions of the director and their relationship to each other. Therefore, the members and the company have to take care that all the objects of the companies are fulfilled by properly following the procedures given in the Articles of Association.